The envelope was sitting on my kitchen table when I got back from the fishing cabin up near Algonquin. My son-in-law's name was on the return address. Inside was a single sheet of paper informing me that my condominium at 14 Birchwood Court in Oakville, Ontario, the unit I had purchased in 2009 and paid off entirely by 2019, had been transferred into a numbered company registered in my daughter's name. I read the letter twice, set it down, and picked up my phone. My son-in-law answered on the second ring. "Dad's home," I said. "Yeah, we know," my son-in-law said. Then my daughter's voice came on, louder, like she'd grabbed the phone. "It's handled. Dad, you're 64 years old, and you've been forgetting things. We decided it was better for everyone if the property was managed properly. The condo is ours now. You should start thinking about a retirement residence." Her husband laughed in the background. "We've already had it appraised. $620,000. Not bad for a family asset, right?" I said nothing for 3 seconds. Then I told them to enjoy their evening and ended the call. I walked to my desk, opened my laptop, and sent 2 words to the email address of Renata Sousa at Sousa Wilms LLP in Hamilton. It worked. Then I poured myself a coffee, sat down, and waited for what I already knew was coming. 4 months earlier, none of this had felt inevitable. I had retired from 31 years as a licensed insolvency trustee with Fuller Greer and Associates in Burlington. I knew exactly how debt worked. I knew what desperation looked like in a man's eyes, and I had watched it building in my son-in-law's eyes for the better part of 2 years. His name was Derek. My daughter Colleen had been with him for 9 years. In the beginning, he had seemed decent enough, a project manager at a mid-sized construction firm in Mississauga. Confident, organized, the kind of man who showed up for Sunday dinners with a bottle of Ontario Cabernet and a firm handshake. But I had spent 31 years watching people explain away their financial situations, and I recognized the pattern. The lease on his truck upgraded every 18 months. Credit card statements he left face down on the counter when I visited. A second line of credit I spotted on a document he'd left open on the kitchen table once and moved away from too quickly when he noticed me looking. Then 14 months ago, Colleen started asking questions she had never asked before. Could I tell her what the condo was worth? Had I updated my will recently? Was I working with a financial advisor? The questions came lightly, as if from nowhere, dropped into conversations about other things. I answered simply, and watched her face for the tells I knew how to read. 3 weeks after those questions started, Derek came to visit alone on a Wednesday afternoon, which he had never done before. He walked around the living room admiring things he'd seen 100 times: the group of 7 print above the fireplace, the cherrywood cabinet in the corner, the view of Lake Ontario through the balcony glass. He complimented the layout, said the building was well maintained for its age, asked, casually, whether I'd ever considered a life lease arrangement. Said some people found it gave peace of mind. I offered him tea and told him I'd think about it. That evening I called my old colleague Paul Greer, who had referred me to Renata Sousa before when a client needed estate litigation work. I told Paul I might be needing her myself. Renata's office was on King Street East in Hamilton, second floor of a Victorian building with original crown molding and a waiting room that smelled like real wood and old books. She was 51, compact, with dark eyes that processed information faster than most people spoke it. She listened for 20 minutes without writing anything down. When I finished, she leaned back and said, "You're describing a man who is planning to use your daughter to access your estate before you die. The question is whether you let him try and document it, or whether you act preemptively, and he finds another way later." I told her I wasn't interested in preemptive. I wanted it documented so completely that no lawyer in Ontario could argue it. She said that was going to require patience and some risk tolerance. I said I'd spent 31 years working with creditors and trustees. I had both. We spent 2.5 hours that first meeting structuring the approach. I transferred my investment portfolio, just over $400,000, into a holding company called Whitmore Advisory Group Incorporated, with Renata as one of 2 directors. I moved my registered retirement income fund beneficiary designation to a charitable trust I'd established years earlier for a literacy foundation in Burlington. I left the condo titled in my own name, clear, attractive, unprotected looking. The bait. Before I left her office, Renata said one more thing. "If they go through with this, you need to understand the timeline. Ontario's property and fraud law is thorough, but it is not fast. You're looking at months. I told her I wasn't in a hurry. Hurrying had never been part of my professional character, and it wasn't going to start now. The recording application on my phone was something my nephew had installed 18 months earlier, when I told him I wanted to be more organized, keeping notes during phone calls. I had never used it for anything serious until the call with Colleen and Derek. I'd pressed the red button before I dialed. By the time Derek said not bad for a family asset, the file was 43 seconds long and sitting in a password-protected folder labeled Property Admin. I attached the audio to Renata's email that night. 2 mornings later, she called me before 8. The recording is clear. The admission about the appraisal, the transfer comment from your daughter that's usable under Ontario law because you were a party to the conversation. I'm pulling the land registry this morning. If they actually filed a transfer, we'll see the instrument number. She called back at 10:47. They had filed. 14 days earlier, while I was still up at the cabin, a transfer document had been registered with the Halton Land Registry Office. The transferring party was listed as me. The receiving party was 2847691 Ontario Incorporated, registered to Colleen Whitmore Garland. My name on a document I had never signed. Renata's voice was measured but direct. This is a Section 380 criminal code matter fraud over $5,000. We're also looking at forgery under Section 366 and uttering a forged document under 368. I'm calling Detective Sergeant Paula Ferraro at Halton Regional Police tomorrow morning. She handles financial crimes. I've worked with her before. She's good. I asked how good. Good enough that she asked me once whether I'd rather be a Crown attorney. That's how good. I had rented a 1-bedroom unit at a quiet building on Spears Road in Oakville 3 months before the cabin trip. I paid 6 months in advance by personal check, gave no forwarding address to anyone except Renata, and listed the rental under my full legal name so there was nothing hidden. I had packed 2 bags before leaving for Algonquin. I had not planned on going back to the condo at 14 Birchwood. The Spears Road apartment was clean and functional, the kind of place that asks nothing of you. A small table, 2 chairs, a single bookshelf I'd brought from storage. I kept my evidence folder on the kitchen table, organized the way I'd organized trustee files for 30 years. Chronological, tabbed, nothing loose. Inside that folder were 8 months of observations, notes from 3 dinners, where Derek had brought up estate planning unprompted. A photograph I'd taken from across the parking lot of Derek's truck, parked outside a Pickering sports betting facility on a Tuesday at 2 p.m. Bank of Montreal account statements from a joint account I'd held with Colleen since she was 18. She was still listed because I had never removed her, and the emergency contact copy provision meant I received duplicate transaction notifications. The notifications showed $44,000 moved out of that account in 7 months. Cash advances, wire transfers to cryptocurrency platforms. Derek's name was not on the account, but the timing of the transfers matched his credit card statements that Colleen had once left out by accident while I was helping her move to the new house. I also had the tape measure photograph. 4 months earlier, Derek had come to the condo while Colleen was in the kitchen making tea. I was in the hallway. Through the open living room doorway, I watched him pull a measuring tape from his jacket pocket and measure the distance from the balcony door to the interior wall. He put it away before Colleen came back. I said nothing. I noted the date, the time, the exact measurement he appeared to record in his phone. The instinct I had developed across 3 decades of professional practice had clicked into place like a deadbolt. Detective Sergeant Ferraro's office at Halton Regional was on the 2nd floor of the divisional headquarters on Cornwall Road in Oakville. She was 48, precise, with a kind of focused stillness that reminded me of the best forensic accountants I'd worked with, the ones who found fraud not by looking harder, but by thinking more carefully. She read Renata's summary brief for 6 minutes without speaking. Then she looked at the land registry transfer document. The signature on this, she said, doesn't match the identification samples you've provided. I told her it shouldn't. I had never been within 300 kilometers of whatever table that document had been signed on. She picked up her desk phone. I'm sending this to our forensic document unit today. Ontario Forensic Document Services in Toronto. They're independent of this division, which matters. I also want the original transfer package from the registry office, not the digital copy. If there's a notarization or a commissioner of oaths stamp on the authorizing affidavit, I want to know who signed it and where. 4 days later, she called. The affidavit was commissioned by a paralegal in Mississauga. She's claiming your daughter presented in-person identification and signed in her presence. But she's being careful about what she says, which tells me something. I'm bringing her in for a formal interview. The paralegal's name was Sandra Buil. She had been operating a small documentation services firm out of a strip mall on Ontario Street. Detective Ferraro interviewed her on a Thursday afternoon. I learned the details later, through Renata's notes. Sandra had told Detective Ferraro that Colleen came in alone, presented what appeared to be valid identification, and said her father had signed the transfer authorization by video conference. The previous week, a procedure that had become loosely accepted in some Ontario practice settings during the pandemic, and had never been fully tightened, since Sandra had not verified the video conference independently. She had not required the grantor meaning me to appear before her in person. She had accepted a printed screen capture of a video call as sufficient evidence of consent. The screen capture showed a man of approximately my age and general appearance. It was not me. When Renata called me with this, she paused and then said, "Colleen found a stock image of a senior man on a video call." That's what she submitted. Sandra's cooperating fully. She knows she violated Ontario's notary and commissioner of oaths standards. She's prepared to testify. The newspaper story appeared on a Wednesday morning, 6 weeks after I had sent Renata the 2-word email. I was drinking coffee at the Spears Road kitchen table when a former colleague from Fuller Greer texted me a link. The piece was in the Hamilton Spectator, written by a features journalist named Carolyn Mast. The headline read, "Daughter says father's fraud claim is retaliation for seeking elder care." The photograph showed Colleen looking distressed, hands folded, eyes directed slightly downward in the particular way that signals grief to casual readers. The story described a devoted daughter attempting to act in her aging father's best interests, an estranged relationship aggravated by the father's decades in the finance industry, and most carefully constructed a suggestion that my professional background gave me unusual and perhaps troubling tools with which to pursue a legal vendetta against my own child. I read it twice. I recognized every sentence as the work of a lawyer, not a journalist. The phrases were too precise, too legally deniable concerns about cognitive function, family members acting out of care, no criminal intent alleged by independent observers. Renata called before I had finished my second read. The lawyer they've hired is Marcus Holt, Bay Street, civil litigation background. Used to work with a major Toronto firm. He's good at narrative. This article is the opening move in a 3-part strategy: public sympathy, psychiatric evaluation challenge, and a civil counterclaim. I'm expecting service of the counterclaim by the end of the week. She was right. Service arrived Friday afternoon. The counterclaim alleged intentional infliction of emotional distress, claimed I had financially exploited Colleen by accepting her assistance managing my affairs and then weaponizing the same records against her, and requested a court order compelling me to submit to a cognitive capacity assessment under the Substitute Decisions Act. I called Renata and told her I had been expecting the capacity assessment request. She said she'd already booked me with Dr. Bernard Aitchison at the McMaster University Geriatric Neurology Clinic in Hamilton for the following Tuesday. I said that was efficient. She said she had worked with Marcus Holt before, and she knew exactly how long each of his moves took. The assessment with Dr. Aitchison lasted 2 hours and 20 minutes. He was a careful, thorough man who did not appear impressed by the legal context surrounding the referral, and was visibly more interested in the actual clinical questions. I recalled a 6-item word list with complete accuracy at the 5-minute and 30-minute intervals. I drew a clock face, showing 10 past 11 without hesitation. I answered every orientation question correctly, including the day of the week, the current Prime Minister, the name of the sitting Ontario Premier, and the approximate current rate of inflation, which I gave within half a percentage point based on the last Statistics Canada release I had read. Before I left, Dr. Aitchison told me that in his clinical opinion there was no evidence of cognitive impairment, memory disorder, or diminished decisional capacity. 2 weeks later, the Ontario Forensic Document Services report arrived at Detective Ferraro's office. Renata had a copy within the hour. The conclusion read, With a confidence level of 97.4%, the signature appearing on the transfer authorization document is not consistent with the known signature exemplars provided for the named grantor. The signature exhibits inconsistencies in pen pressure, letter proportion, and baseline alignment that are characteristic of a simulated signature attempt rather than the natural production of the named individual. Fraudulent. Documented. Irreversible. Detective Ferraro charged both Colleen and Derek. Colleen faced fraud over $5,000 and uttering a forged document. Derek faced the same fraud charge plus a conspiracy count. 3 days after the charges were laid, I was in my Spears Road kitchen at 7 in the morning when my neighbor across the hall, a retired postal worker named Glenn Beauchamp, knocked to tell me there was a man with a trailer in the Birchwood Court visitor parking lot, and he appeared to be loading items from the condo into it. Glenn had lived at Birchwood Court for 11 years before I moved in, and had stayed in touch since I'd left. I called Detective Ferraro immediately. She called the Oakville Property Crimes Unit. 2 officers attended within 20 minutes. The items Derek was attempting to move were a 1,984 Inuit soapstone carving I'd bought at a gallery in Yellowknife, a mahogany writing desk that had belonged to my late wife's family, and 3 pieces of matching silverware from a set we'd received as a wedding gift in 1988. Derek had listed them on a Facebook Marketplace account the previous evening, under the name of a numbered company he'd created 6 weeks before the charges. The price he had listed was $1,400 for the lot. The actual value was closer to $11,000. He had not sold them yet. The officers prevented the transfer. The attempt was added to the Crown's disclosure package as evidence of intent to dissipate assets. When Renata called me that afternoon, her tone carried the particular careful satisfaction of someone who has learned not to celebrate too early but cannot completely contain it. He tried to sell a family heirloom on Facebook Marketplace while facing fraud charges, she said. Marcus Holt is going to have a very difficult time explaining that as the behavior of a man who acted in good faith. The preliminary inquiry was held in Ontario Court of Justice, Courtroom 4 at the Milton Courthouse, on a Thursday in late November. Colleen sat at the defense table in a gray blazer, hands folded, still performing distress for whoever was watching. Derek sat beside her in a suit that was slightly too large through the shoulders. Marcus Holt was polished, prepared, and argued his procedural motions with the smooth confidence of a man who had done this 1,000 times. He challenged the admissibility of the phone recording. Justice Elaine Pemberton reviewed the relevant criminal code provisions in Ontario case law and admitted it. He challenged the objectivity of the forensic document examiner. Justice Pemberton ordered a second independent analysis. He raised the capacity question. Justice Pemberton reviewed Dr. Ackeson's report, noted its clinical thoroughness, and declined to order a second evaluation. After the inquiry, in the courthouse hallway, Renata touched my arm. She's not impressed with the motions, but she's granting everything so the record is clean. This is going to trial with a complete evidentiary foundation. No gaps for appeal. I told her I had expected as much. The trial was set for a February date at the Milton Courthouse. Marcus Holt filed 2 more motions before then. Both were denied. He filed a civil counterclaim on Colleen's behalf, inflating the allegations further with claims that I had discouraged her from pursuing professional employment during her 20s by insisting she join a family business that had not in fact existed, a fabrication so transparent that Renata dismissed it in 4 paragraphs. What I had not anticipated was the letter. It came on a Monday evening. Handwritten on cream stationery, Colleen's script. The same looping letters she'd used since elementary school. 4 pages. She described growing up feeling that nothing she accomplished was ever quite sufficient, that my professional precision had made warmth impossible, that Derek had seemed at first like someone who finally accepted her without conditions. She said she knew what they had done was wrong. She said she was sorry. She said she was more afraid of what prison would mean than of anything else she had faced in her life. I sat with the letter for a long time. I thought about her at 8 years old, helping me rake leaves in the backyard of the house on Morrison Crescent. I thought about her standing at her mother's grave in 2017, not crying, until 3 days later when she finally called me at midnight and didn't say anything for the first 4 minutes. Then I called Renata. I told her Colleen had written. Renata asked what I wanted to do. I said I didn't want Colleen in prison. I wanted Derek held accountable for what he had planned and what he had executed. and I wanted to never hear from either of them again. Not out of cruelty, but because I had learned in my professional life that proximity to someone who has done what they did does not lead anywhere good. Renata said she would approach the Crown about a division in the case. Colleen would plead guilty to the uttering charge, receive a conditional discharge with 3 years probation, pay full restitution, and consent to a 10-year no-contact order. Derek would proceed to trial on all counts. The Crown agreed. Marcus Holt resigned from Derek's file. The new defense lawyer, a younger man from a smaller Brampton firm, negotiated poorly and slowly. Derek's trial lasted 4 days. The forensic document examiner testified for 90 minutes and was unshakable under cross-examination. Detective Ferraro's testimony was methodical and complete. Sandra Buil testified that she had been told I was too unwell to appear in person, that the screen capture had been presented as proof of my consent, and that she had known at the time something was wrong and had proceeded anyway, something she stated she would carry with her professionally for the rest of her career. My own testimony lasted 55 minutes. I described 31 years as a licensed insolvency trustee, the specific observations that had prompted my suspicion, the precise steps I had taken to document the scheme, and the moment I returned from the cabin and found the envelope on the kitchen table. The Crown played the recording. Derek's voice filled the courtroom. We've already had it appraised. $620,000. Not bad for a family asset, right? I watched the jury. 7 women, 5 men. 3 of them over 55. When Derek's voice came through the courtroom speakers, 2 of the older jurors exchanged a look that told me everything I needed to know. Derek took the stand, against his own counsel's advice, and testified that he had believed I wanted them to manage the property on my behalf, that the transfer had been my idea, that the confusion arose from a misunderstanding. When the Crown played the recording again during cross-examination and asked him to explain how a misunderstanding produced an appraisal and a registered title transfer without the owner's knowledge, he said the situation had been more complicated than it appeared. The jury deliberated for 3 hours and 20 minutes. Fraud over $5,000, guilty. Uttering a forged document, guilty. Conspiracy to commit fraud, guilty. Mischief to property in relation to the Facebook Marketplace removal attempt, guilty. Justice Pemberton sentenced Derek to 32 months in a federal institution, a fine of $25,000, and a restitution order covering all legal costs, the property damage assessment, and the outstanding unpaid debt obligations that had been the engine of the entire scheme. The financial investigation had traced his actual total debt load to $481,000 across 9 creditors' credit cards, a personal line of credit at TD, 3 cryptocurrency lending platforms, and 2 private lenders charging interest rates that came close to criminal code threshold provisions. He had been trying to use my condo to make all of it disappear. I moved back to 14 Birchwood Court in early March. The first morning, I made coffee and stood on the balcony looking out at the lake. The February ice was just starting to break near the shore. A pair of Canada geese were picking their way along the rocks below, unbothered and purposeful. My colleague Paul Greer called that afternoon. He had seen the coverage in the Hamilton Spectator, a follow-up piece, accurate this time, focusing to document evidence in the verdict. He said it was good to see the system work the way it was supposed to. I said it was, though it had taken longer than I had hoped and cost more than I had budgeted. Glenn Beauchamp from down the hall knocked in the evening, same as always, and we talked for 20 minutes in the doorway about nothing in particular: the geese, the building's plan to replace the elevator panels, whether the coffee shop on Lakeshore was going to reopen. Normal things, the kind of conversation that means you belong somewhere. Renata emailed the following week. The restitution schedule had been formalized. The case had been referenced in a Law Society of Ontario bulletin on the use of digital identity verification in property transactions, specifically as an example of a gap in current practice that had been exploited and needed legislative attention. She said 2 other practitioners had called her asking how I had structured the documentation. I wrote back thanking her and told her I hoped she'd accept a dinner at the Hamilton Club as partial payment for everything she'd done. She wrote back one line: "Make the reservation." Colleen's probation officer had confirmed she was complying with all conditions. No contact, no communication, The 10 years would pass. What happened after that, I didn't know. I had left the letter she'd written in the drawer of the writing desk, the one Derek had tried to load onto a trailer at 6:30 inches the morning to sell on Facebook for $1,400. I wasn't ready to answer it. I wasn't sure I ever would be. But I had not thrown it away. On a Sunday in late March, I drove up to Algonquin for the weekend. I left Friday morning, took Highway 11 north through Barrie and Huntsville, pulled into the access road for the cabin site just before dark. The lake was still mostly frozen. The ice made sounds in the night deep, resonant cracks as the temperature shifted, and in the morning there was a skim of new snow on the dock. I sat outside for 2 hours with my coffee, listening. I thought about the 31 years I had spent helping people understand the consequences of borrowing against a future that didn't exist. I thought about how clearly I had seen it in other families, and how long it had taken me to see it clearly in my own. I thought about my wife, Patricia, and what she would have said about all of it. She would have been devastated by Colleen and furious. In the particular quiet way she had, not loud, just very still, very precise about what had been done and what it meant. She would have said that you do not let a wrong stand simply because the person who committed it shares your name. And then, after a while, she would have said that doors don't have to be closed forever. I didn't know which of those things was right. Maybe both. Maybe neither. That was the part of this no verdict could settle. What the verdict had settled was the condo at 14 Birchwood Court, the investment portfolio inside Whitmore Advisory Group, and the writing desk in the corner of the living room with the letter in its drawer. All of it was mine. All of it had been protected. The ice on the lake shifted again. A long, low sound that carried across the water like an announcement. I finished my coffee and went inside to make breakfast. If this story meant something to you, please take a moment to like the video and subscribe to the channel. Drop a comment and tell us where you're watching from and what time it is there. And if you'd like to hear the next story, it's just one click away.